So my name is Alexey Ivanov, and I'm director of the BRICS Center for Competition Law and Policy, as well as Institute for Law and Development, HSE-Skolkovo, which is part of High School of Economics National Research University here in Russia, and associate professor at the law school here at HSE as well. So I work in the field of competition law and policy, and BRICS Center is a kind of initiative established in the course of cooperation of the BRICS authorities, but also in the course of cooperation of the BRICS academics. And the most important thing, I think, most important achievement of our work so far, we are working a little bit less than 1 year, is to bring together people from different BRICS countries and also international academics interested in developing world, in developing of competition law and policy discourse around the world, and put them together in a cooperative framework which would help to build ideas together and also to change a little bit established narrative of the current regulation of the global economy. Because we do need alternative narratives, we do need some sort of heresy in this sphere, because a lot of dominant ideas which already turned to be bankrupt in terms of outcomes. We saw those outcomes, we see the growing inequality, we see the growing imbalances in the global economy, we see the stagnation of growth, we see a lot of negative things, we don't see solutions yet. So I think any initiative which helps to bring those solutions at least at the table for discussions, at least, come up with some new ideas, it's extremely necessary, needed, and I would say even imperative we should have this. So that's basically our small contribution to this change of the global dominance of market in the market of ideas, global dominance of certain, I would say, rigid approaches to regulation of the global economy. And with the digital economy, it's maybe even more vocal and necessary than with other kind of forms of our economic life, because with digital economy we see the growth of new mythology that digital allows you to do whatever you want. Digital is good, so everything which has digital element should be kind of released from regulatory scrutiny, from all sort of intervention. It's a kind of magic world which allows businesses and even monopolies to avoid some sort of regulatory control, public control, and I think it's quite important topic to further elaborate. And at this point, I finish my introduction. I just say a couple of things about the schedule of our work. First of all, it's very informal, as I highlighted already, and so we encourage all sorts of interventions and open discussion, and we don't have structured presentations this morning. It's very important. So we try to make our conversation like a home-like style, So we're more like friends discussing things than anything else. So it's very different from what will be tomorrow, the day after tomorrow, in the day after tomorrow at the BRICS conference. There would be also friends, but in a much more structured setting. So we start with the first panel, which we called Next Generation Competition. It's a very broad topic, and Lianos, my colleague who will chairs this panel, will say a couple of words more what it would be, and all the rest also have their names, but those names are indicative rather than imperative in a sense. So you can move around, you can present something related, but not exactly be strictly tied to this title. And we have also dinner after our nice seminar, and a number of coffee breaks and lunch. So a lot of time to network, to talk to each other, and that's basically our main purpose for today's event: to bring people together, connect them, and let them to talk. Okay, that's my introduction. And please introduce Professor Ioannis Lianos.
No, that's okay. I mean, thanks very much, Alexey. For the interest of time, I will ask the people that are part of panel 1 to come and sit here. So my name is Ioannis Lianos. I'm professor of global competition law and public policy at UCL and newly appointed head of the Hellenic Competition Commission. Therefore, what I say today represents my own personal views and in no way engages the Hellenic Competition Commission. During the last year, I've been involved leading basically and coordinating a team of BRICS and international academics that drafted together a report on the challenges of the digital age for competition authorities, in particular developing countries and the BRICS. This report will be released tomorrow evening. It's a quite long report. It's more than 1,000 pages long, and I hope interesting, so you can spend time reading it, which actually deals with all the possible policy issues that may arise in this context and tries a little bit to map the activity so far of the BRICS competition authorities in the digital economy. Obviously, a number of the speakers today have been involved in the drafting of this report, and therefore they will share the experience and the collective learning we all had from this quite interesting experience. I really like to insist on what Alexey mentioned before on why the digital economy and why looking to competition and policy in the digital economy is important for developing countries. I think that we are witnessing phases of early disindustrialization because of the emergence of new technologies, for instance, artificial intelligence, which could replace white-collar workers, and robotization that could replace blue-collar workers, that may, to a certain extent, erase the advantage, the comparative advantage that developing jurisdictions may have in the context of the cost of labor. And therefore, it is extremely important for developing countries to realize that things cannot, work as in the past. I mean, this is a new industrial age, and therefore they need to be ready to deal with that, and in particular deal with the issue of dataification, which is, as we're obviously going to discuss, is an extremely important element in this new economy. So the workshop that has been organized, I would say, entirely by Alexey, because of this new role, I have been unable to basically do anything about this conference, unfortunately, the last month. So this actually workshop is meant to be an informal exchange of views about and ideas about the digital economy and competition law, in particular for developing countries. One should take it as a brainstorming session. The report that we'll release tomorrow is still a draft report. We call it draft report because of the fact that we want to obviously get from you feedback and comments, and obviously the report will be finalized in the next month or so with also the after being also reviewed by the heads of the International Advisory Board of our group, Professor Joe Stiglitz and Eleanor Fox. So that is for my introduction. I therefore ask the members of the first panel to join. So Eduardo Ribeiro, Paulo Furquim, Andrey Shastitko, Raisa, Cachalia, and Alina Velias, who is going kindly agreed to replace Patricia Sakowski, who unfortunately wasn't able to come today because of some unexpected work and other duties that she had to fulfill. So the first panel will basically set the whole debate, in a sense, introduce a debate, in particular looking to what some have called the next generation competition, how actually the digital age maybe sets challenges to change the paradigm of competition law. So introducing a little bit this topic of next generation competition, I think there has been quite a lot of ink for those of us that still read papers, spent on multi-sided platforms, multi-sided markets, platforms, and how these change the competitive game. So we're going to have a quite interesting discussion of this topic by Eduardo Ribeiro, who has contributed to Chapter 2 of the BRICS report with a number of, obviously, other authors from BRICS, economists, on the economics of platforms. Then, actually, what I would like to do is to bring in a little bit this discussion, which is global, to a more localized context. Therefore, we have a number of academics from BRICS jurisdictions who can comment on the overall framework, but can also relate that framework to the experience they had in their own jurisdiction in terms of how actually the economy, the digital economy, their own jurisdiction has developed, how the domestic companies have been able to deal with digital platforms. Is there any major digital platform? What are the competitive issues that arise, in particular through the development of ecosystems that are managed by the platforms that play, to a certain extent, a gatekeeping role? Therefore, we're going to start first with Raisa Cachalia from South Africa. She's actually the second woman, so we are more or less all right in terms of gender balance. So then, followed by Paulo Furquim. I don't see Andrey Shastitko, but maybe he will join us later. We are going to have Paulo Furquim, of course, the Andrey Shastitko, and then we're going to have benefit from the comments of Alina Velias, who is an economist working on an industrial organization, and she obviously knows quite a lot about that. All right, so may I ask Eduardo to start, and and we can actually then have probably some time for discussion, questions, and answers from the floor.
Good morning, everyone. Thank you for the opportunity, Ioannis, Alexey, the opportunity of being here and starting the discussions today. The material that I'll be discussing is actually joint work with Svetlana Avdasheva, Svetlana Golovanova, and Dina Kornieva. And what my role, I'll be brief, and I'll just try to start with the basics, which is what are we discussing, which is really different from other types of businesses. Platforms, they are very important new form of organization of businesses in services and retail that exploit cross-network externalities. So they exploit the strength of and the power of the internet to solve information issues and contractual issues from both sides, sellers and buyers, or different type agents that want to interact economically. So they seize this opportunity and they seize proposing new business models or improving other business models to make money out of it, of course. And if you think about this cross-network externality, which is something that was the idea of network externalities that you certainly have heard about, and you probably hear a lot about today, means that it's the attractiveness of a business depends on the number of users from the other side of the transaction. Either if you are a seller and a buyer, of course, it's good for you. If you want to buy something, you want to reach the largest possible number of sellers for you to have a more informed choice, or you want, as a seller, you want to reach the broadest possible pool of consumers for you to propose your business and try to reach them. And network externalities started to come to the forefront of economic analysis when we started to seeing the so-called network networks from communications, and cross-network externalities would be these externalities that appear between sites, not from the same site. Of course, if I on the usual and the old example of the on-site network externality was from mobile phones, it's good for me to have a mobile if I can call other users, or if I have an email. Remember the time that we used to pay for email? It was interesting. It was only interesting for me to have email if I had a lot of colleagues that also used emails. So the network externality was this advantage of using a tool or using a product that more people used. On cross-network externalities, we see that appearing on both sides. But platforms are also businesses that you see them appearing related to digital markets. And digital markets also have their own characteristics regarding their cost structure, low unit costs and very high fixed costs, or at least you have large steps of being able to service more and more people. In addition, there is learning by doing, so there is a practice of how to make the service more efficient or effective in the sense of providing reliable service on one hand, and at the other hand, a view to lower the costs. And something that may be new for these digital platforms is that you have learning by doing by the algorithms that provide a better matching between, for example, if you're a platform that tries to connect advertisers with audience, you want to have your business will be more attractive the better you can do the match and guarantee that the type of consumer that you're reaching fits the best the interests of the advertisers. And on top of that, you have innovation. You see that I've discussed new ways of doing business, or how to improve current business. We've seen transportation, private transportation in the sense of a taxi. Taxis have been around for decades or centuries. Now there are new ways of putting together drivers and passengers, which is what some of the platforms do. So those are innovation-based businesses, and that's another characteristic that we should look and have in mind when comparing and when analyzing and understanding the competitive effects of platforms. So cross-network externalities, cost structures, economies of scale, learning by doing, and innovation-based. So those are the background, I would say, that the supply and demand characteristics that appear in many of the platforms that we discuss, and something that you may see happen maybe again is that it's a mixture of old ideas in the sense that with the economics and law and scholars have been dealing with sectors where there are wide economies of scale and how to regulate them or how to organize a market that can be more efficient under extensive economies of scale. And there may be markets innovation-based, for example, pharmaceuticals, but platforms are different in the sense that they put everything together in the same at the same time. And that's basically the biggest challenge, where you have to take into account all those dimensions when looking at them and making that analysis. At the same time, and this would create has consequences for the analysis in antitrust in particular. And if I take a very close just competition antitrust analysis, of course we should start by thinking about relevant markets. And those platforms, you may think that they are different in the sense that sometimes we're used to see markets where you see a transaction. You see both sides sitting and actually exchanging goods from one side to the other or providing a service. Some platforms, you have a separation of the contact between one side and the other. Everything is intermediated by the platform itself, and so you have the so-called non-transaction platforms, because the platform is the one that's actually doing the intermediation, but not actually putting the two individuals together. Some of the platforms do have business that try to move from a non-transaction to an actual transaction. If you think about some of the algorithms the pricing that Google does, for example, on a browser, it wants you to learn exactly who was on the other side clicking and using that to price. But mostly you have audience markets or advertising-based markets that are so-called the non-transaction. And on the other hand, you may have the markets where even the way that the platform is able to monetize the service that's making, it's through the transaction itself. So you have to think that there are different ways of platforms organizing themselves in the way of how do they make their business and how do they monetize and earn earnings. So you will hear a lot of those ideas floating around here. Again, I think that the main thrust and the main point is that we've seen those ideas separately floating around on different markets, but digital markets and platforms, they put everything together in a very fast and changing business environment that even some dominant platforms ended up disappearing in clear, as we should expect in innovation-based markets. I don't know if you ever had a Microsoft network account or Messenger account or Orkut, if you remember those. They change. So and our work is basically trying to organize the discussion due to these characteristics that are put together in platforms, and how should we adapt or improve on the competition tools that are available currently. Well, I would just highlight some conclusions that we've had from our research, and I'm sure we will have more time to discuss details on about those results. First of all, if we are thinking, I already argued about how to think about markets, whether you think about markets where the transaction is actually how firms monetize their services, and non-transaction when firms provide the opportunity to make people get together but don't observe the transaction itself. If you think about tools for the limiting markets, and you think about the critical loss and hypothetical monopoly tests, the demand side has an important role and will be the one that will have to change the formula that's used for critical loss analysis. So in this case, for defining relevant markets, what platforms bring as novelties, the idea of the cross-network externalities, and when those cross-network externalities are relevant, and then you should adapt the formulas. Otherwise, you can continue doing the way of using the formulas as you usually did. Generally, because of the positive cross-network externalities, which means if the demand on one side increases as you have more people on the other side of the platform, which means a cross-network externality that's positive, the usual tools will give too narrow markets because they don't take into account the losses that come from unilateral price increases from the hypothetical monopolist, which on one side of the market, which also reduces total revenues and profits. So profits from the other side. So if cross-network externalities are positive and relevant, you will need to adapt your critical loss tool if you're using that as a quantitative tool. If you think once relevant markets are defined, and if you go on and want to have some information about unilateral price effects, again, if at least one of the prices of the sides, charges a positive price, you would need to adapt your GUPI or UPP formula, which again take into account the cross-network externalities, that the demand side is relevant for understanding these unilateral price increases, for example, after a merger. If we go further and think then not only as far as mergers are concerned, but as well if you think about abuse of dominance cases or abuse of dominance business practices, then both sides, both cross-network externalities and the supply side, the cost structure, the tipping points, the learning by doing, and the dynamic competition issues become as important as the demand side for you to understand the possible anti-competitive effect of exclusionary practices. Sometimes, depending on the cross-network externalities, may reinforce and make economic sense out of some business practices that are exclusionary and try to deter enter. And that's something that comes with the analysis that we see on platforms. On the other hand, price-cost comparisons, though that were already difficult to make as evidence of the possible anti-competitive effect of exclusionary practices, they become more difficult to measure and to use as evidence of actually exclusionary practice. Because when you have the demand side and the idea of the platform, of the intermediation, not just as retail buying and selling, but actually solving informational issues and creating this hub where sides can negotiate or learn about each other, the price comparisons, they become much more difficult under cross-network externalities, because the platform will understands the effects on one side on the other and sees as an opportunity cost on their own cost to serve one side of the platform. It understands the pricing generates an opportunity cost on the other side of losing or earning more users on the other side. And so the price to serve one of the sides may not be the appropriate cost that the platform is using to take their own decisions. It takes into account also the cost from the other side, or it takes into account the opportunity cost of providing service on the other side. And so you have to have a broader view and a more complex and complete view of what's going on both sides of the business. It seems, again, and last, before I go to my conclusions, network externalities create tipping points. Learning by doing also generates minimum threshold levels of time or the opportunity to be active in the market that make exclusionary practices more rational, in the sense of being able to recoup, if not recuperate some lost profits in an earlier stage, it will generate an opportunity for higher profits further down the road. All of this is so platforms bring together these ideas, and that we have to look more closely and adapt in the sense of what we always did as, if you think of antitrust authorities or scholar or as business people. Let's step back and always look at how the business work. Learn the business, learn the incentives, learn the ways to make money, and as economists and lawyers see how these ways of making money generates efficiencies or generates inefficiencies, and there may be other ways of organizing business and individual activities. So I hope that with this brief introduction, there were many ideas that I tried to bring here, can provide a good start for my colleagues and you on the audience to discuss. So thank you.
Thank you very much, Eduardo, for this panorama. Very, very insightful. 2 points that I will raise later, so it's good maybe to start thinking about them. Is you emphasize the importance of still defining a market. I mean, the step of defining a market that could be challenged by some, including the majority opinion of the U.S. Supreme Court in the Amex case, where the idea was that for a transaction platform will be the market to a certain extent. So there's no maybe need to look to relevant markets. And there are also some theories that have been floating around about by some scholars, which I will discuss later, the so-called oligopoly hypothesis, which basically somehow puts away any emphasis on relevant markets and focuses basically on the characteristics of the firm itself. If it's basically an innovative firm, if it's, I'm just narrating this theory, if we can call it a theory. Is more of an hypothesis, and basically, somehow puts the question of defining a market at the back burner rather than actually being a very important and relevant fact, starting somehow the competition assessment and competition screening. And the second issue is you mentioned the existence in these markets of positive feedback loops, and one of the characteristics of positive feedback loops is the fact that they are leading to non-linearity, and that leads to the possibility of multiple equilibria emerging, and obviously that, to a certain extent, might be a concern for the competition economists, as far as I understand it. At least I'm not an economist myself, but I think that could be an interesting issue to discuss. I mean, all these aspects, of the tipping points and leveraging points, etc., and the fact that things can change pretty drastically in a certain way. One of the arguments of this oligopoly thesis is that firms, even if they are dominant in a specific market, they are basically fearing continuously, almost at the paranoia level, disruptive competition, and therefore they are behaving as if they are in intense oligopolistic competition with other firms that are not even present in the same market, and there are not even overlaps basically between the firms, but they are somehow a little bit like Don Quixote and the windmills. They are basically out there, some kind of a potential competition. It's an hypothesis. I'm actually just mentioning this because it has been put forward by some people. And the other actually argument. So this is an argument basically in favor of not intervening. Rather than intervening through competition law. The second argument has been put forward by other people as well, and this is in the context of the intra-platform competition, is the fact that, the relation between the platform and the businesses that are basically part of its ecosystem is a relation of genuine commercial agency. So basically, they are as if they are part of the same firm. And therefore, this argument goes, competition laws to stay away from intervening in this context in the same way that competition law has stayed away from intervening in the context of intra-enterprise, basically, dealings or, for genuine commercial agencies. So that is an argument that basically builds a theory for a competition law immunity for any intra-platform competition matters for a platform basically governing its ecosystem. And that approach has also been put forward by a competition law scholar, is to a certain extent, I think, also shared by the oligopoly hypothesis, which basically leaves the platform sort of a carte blanche to do whatever they like in their ecosystem, because this is an innovative platform and it spends a lot of money on R&D, etc. That's the argument, right? So, I mean, we can think whatever we can about the seriousness of these arguments, but I'm just putting them forward as basically arguments that have been put forward by some people and to engage with when we discuss about digital platforms and competition. But again, all these different points come up to the idea that we shouldn't really look to relevant markets. We shouldn't really look to, as a starting point, let's take a step back or a step, after. I don't really know how we can call it, and let's basically not focus on relevant markets and possible impact on relevant markets. So that's one thing that I want us to discuss, and maybe later, after obviously we heard now from Raisa about the situation in South Africa and more generally the competition laws that arise in the digital economy. In particular, public procurement, I think you'll be discussing.
Okay.
Yeah, thank you.
All right. So, good morning, everyone. So, just an upfront disclaimer: I'm more of a procurement lawyer than a competition expert, but there's a very important and special provision in the South African Constitution that provides that when the state contracts for goods and services, it must do so in accordance with a system that is fair, equitable, transparent, competitive, and cost-effective. And kind of what would be of special interest to today's discussions is a rather novel but increasingly interesting point of intersection between these two regulatory spheres. And that is when the private sector tenders to bring the state into the digital economy and the kind of competition issues that arise in that context. And I'm really just going to be exploring how these issues have kind of played out in the context of our social grants litigation in South Africa. So technology, as we can all appreciate, holds immense promise to improve the quality of governance in developing countries, and public procurement in particular remains one of the most important tools in the hands of the state to advance this objective. But things can also go awfully wrong, particularly when confronted with a state that is technologically unsavvy, often the case in the developing world, unfortunately, and where there are few, if any, competitors offering a viable kind of technological service delivery option in a given market at a given time. So this absence of real competition undermines the ability of governments to acquire the best possible technological solution at the best possible price. A reality that is also kind of exacerbated by the slowness on the part of governments to develop their own technological capacity and ultimately to hold contracted service providers accountable for what they do ultimately provide. Thus becomes paramount for the state to structure their procurement processes in ways that really maximize competition, even if this means sacrificing some of what it could have gained through a more one-dimensional focus on a very particular kind of technological solution. And I'm going to kind of explore this argument or this theme that I'm kind of developing in the context of the social grants litigation. So in South Africa, the debacle surrounding this massive social security tender does bring many of these issues to the fore. SASSA, which is South Africa's social security agency, was established to bring a disparate system of grants management and payment under the umbrella control of a single government agency. Okay? The system SASSA inherited was fraught with difficulties, disintegrated social security systems, lack of uniform grant administration processes, ineffective IT systems and interfaces, costly administration fees, fraud and corruption, and poor management of outsourced payment services. More particularly, the fact that large volumes of cash were being physically transferred to various payment points across the country, some located deep in the rural countryside, was an obvious kind of security risk. And the manual way of verifying beneficiaries, both at enrollment and payment stage, was proving to be an intractable difficulty from a fraud and corruption perspective. So the unfortunate reality was really that SASSA at the time neither had the resources nor the capacity, technologically or otherwise, to overcome these challenges itself, and it had no choice but to turn to the private sector for assistance. To this end, in 2011, it issued a tender for the countrywide management and payment of some 21 million million social grants, about 15 million vulnerable beneficiaries in the country. The tender was arguably one of, if not the most important procurement contract for the provision of services to the South African public in the democratic era, not only because of the value of the contract, so roughly 10 billion rand, but for the sheer number of vulnerable people that would depend on pensions, disability, and child support grants for their economic survival. The fact that total expenditure on grants in the 2017-18 year financial was estimated to be in the range of 150 billion rand is further testament to its importance. So significant for present purposes is that the tender sought to confront the enduring challenge of paying the right social grant to the right person at the right place and time by stating a preference in its proposals for some sort of biometric solution. So biometric verification of beneficiaries, typically by fingerprint, but also by voice recognition, at least at the point of enrollment, but if possible and available, also at the point of payment. The strong preference for a biometric solution can also see in the kind of two-stage process of evaluating bids, which were first to undergo what was called a technical evaluation, where a minimum score of 70% on the technical proposal had to be attained in order to progress to the second stage, which was really an assessment of the competitiveness of the pricing and the extent to which the company commits itself to preference, as in kind of transformation of the economy. And even if this kind of high 70% threshold was actually met, proposals would still then be subjected to a reassessment at an oral presentation. So after issuing this RFP, but before the date of submission, SASSA proceeded to change the requirement of biometric verification from being a kind of preferred solution to a mandatory one. So what essentially happened then is you had initially 21 companies that were going to be participating in this procurement process, but the effect of changing the terms of the RFP meant that there were actually only two bidders of those 21 that were able to provide a very basic compliance solution. Okay, so that reduced obviously the pool of competitors, So we had a mere two bidders left, and that was AllPay, who is a subsidiary of Absa Bank, and Cash Paymaster Services, which is a subsidiary of the global Net1. And so AllPay and Cash Paymaster both made it past the initial technical evaluation, both scoring at least 70%. But following the subsequent oral reassessment, AllPay was essentially kicked out, and you had a situation where a multi-billion rand tender could only actually be awarded to a single entity. This was Cash Paymaster. And what essentially happened was SASSA, so desperate to kind of secure a particular kind of technological solution, essentially accepted CPS's proposal kind of at face value. So they didn't interrogate either the competitiveness of the pricing, the quality of the service offering, or substantively whether it was going to further the goals of kind of fairness and preference. So the result was, AllPay is kicked out, CPS is the only remaining bidder with a compliant bid. And the upshot was that, the lack of another compliant technical proposal meant that SASSA was unable to assess the quality and ultimately the competitiveness of CPS's biometric solution against any other offering. So AllPay challenged this award in court on various bases, and I cannot tell you the number of iterations this tender's gone through in the courts. I mean, I think they've been in a range of about 15 different judgments dealing with this. And so our highest constitutional court ruled that the tender process had been materially irregular, and the court held that SASSA's last-minute change to the bid requirements reduced the number of viable bids to one, which rendered the entire process uncompetitive and made a comparative assessment of cost virtually impossible. This finding notwithstanding, the court's hands were apparently tied. The threat of disruption to this, by the stage this litigation was heard, this tender had been running for in excess of 5 years. And the threat of disruption to this crucial public service, which impacts significantly on the livelihood of millions of vulnerable people, meant that out of necessity, the contract had to remain in place. And this was at least pending the outcome of a fresh tender process, which SASA was then ordered to run. But the outcome of the subsequent tender process did nothing to alter the status quo. None of the previous bidders bid this time round. We had a very small bit of pool of bidders, and Allpay, who was the only kind of entity that could provide some sort of viable technological solution at that point, chose just not to tender. So, I mean, in the end result was that CPS's contract remained in place, and notwithstanding SASA's initial undertaking to start actually insourcing the function, its inability to do so meant that, the status quo essentially remained, and CPS continues to benefit from this highly lucrative, but in the end, unlawful contract. So the saga doesn't end there, and that's where kind of the discussions become relevant for what we're concerned with today. But there were revelations in the media, both during and after the litigation, that CPS had actually kept very few of its original promises, and worse, that it may have been abusing its position for the financial gain of the company. Though CPS was given the tender because of its biometric capabilities, in practice, the distribution of grants has actually fallen far short of these commitments. The voice verification technology, which was really the basis upon which CPS was awarded this tender, What CPS essentially undertook to do was to be able to verify payments to beneficiaries, both at the point at which beneficiaries were enrolled onto the SASA system and at the point at which individual beneficiaries were paid. They would use either fingerprint recognition in respect of cash payments or voice recognition technology in respect of electronic payments. So, though the tender was given to, the voice recognition technology was actually never sophisticated enough to work effectively. So this is despite what they said on paper they would do. And it's virtually been abandoned, with the result that 60% of grant recipients who are using banking services essentially receive grants as Allpay had proposed. That is without monthly verification. In addition, it seems that the fraud reduction justification for insisting on biometric technology is also not materialized. What is perhaps worse than these broken promises are the scathing allegations against CPS, essentially accusing it of illegally harvesting the personal data of grant beneficiaries and using this information to lock beneficiaries into using their grant money to pay for other financial services, such as airtime, loans, and electricity, that are actually provided by Net1, which is CPS's holding company. So what's the bottom line? Notwithstanding SASA's best intentions of bringing the social grant system into the digital era, what has happened in practice is actually, it's really sobering. The South African public is still today stuck with CPS, who was awarded a contract arising from a deeply flawed tender process, one riddled with irregularities, and whose proposal was never subject to genuine competitive assessment, whether for price or for quality. Moreover, CPS has also, despite its tender commitment, failed to provide a viable technological solution able to overcome the plethora of difficulties afflicting the social grant system. And finally, if the allegations in the media have any truth to them, which is a strong suggestion that they do, CPS has been abusing its access to the much cherished personal information of millions of grant beneficiaries for the financial gain of the company. Against this rather kind of depressing backdrop, it's perhaps apt to ask, how can developing states leverage private sector innovation to better the quality of governance and service provision in these countries? While it's not a perfect solution, perhaps the answer lies in more competition, not less. So what I mean by this is that in the absence of having kind of perfect competitors in a given market at a given time, which is often a reality in this kind of age of disruptive technologies, it is incumbent on the state to make their procurement processes as competitive as possible, even if it means relaxing its tender requirements and settling for a less perfect digital solution, but one that nevertheless was assessed genuinely and holistically against the wider pool of proposals. The final point is that there were a lot of problems with the social grants tender. Okay, it was deeply flawed on a number of levels. But I would argue that one of the problems was a kind of overly strict and overly ambitious tender process with requirements that given the market at that particular time, there was maybe one player who could satisfy these strict requirements. And, given that we have a state that's so technologically unsavvy and essentially unable to scrutinize the competitiveness and the value of these service offerings individually, I think the point is that, you actually, what you need is more players providing less perfect proposals and less perfect digital solutions than a kind of preoccupation with the perfect digital solution. Thank you.
Thank you very much, Raisa, for these very insightful remarks. Of course, we have so far thought about the role of the state in promoting competition in digital through, for instance, the possibilities that are offered by distributing data that is collected by the state, like the European PSI directive and now the Open Data Directive puts forward. So that's a role, basically, of the state in somehow putting data out there, publicly collect data in order to promote competition and new entry. But you raise an interesting point of how also the state should be in itself integrating competition law and policy principles in its own action, in particular in the context of public procurement. And although public procurement is there to create competition for the market, nothing basically guarantees us that once, a particular project has been awarded, there will be, competition in the way this project will be managed. And your example reminds me a little bit of this disaster that has been the public-private partnership, the London Underground. Those of you that know, actually, it was a public procurement, but one of the companies basically used the subcontracting possibilities that were offered by the public-private partnership to grant the work to at very inflated rates to one of its shareholders companies that were basically quite big company situated in Canada, started with B and finishing with R. So, maybe you can imagine which company I'm talking about. With the result that basically Metronet was the name of the London Underground company that was basically managing some of the tube lines, would bankrupt and had to be saved by the state, because obviously you can't leave a couple of lines, even one in the London Underground, to collapse. You can imagine the social cost of that. So, which basically brings to the fore the idea that when thinking about competition is not really just about creating rules of public procurement, but it's also important to follow up and maybe even provide some advocacy functions to the competition authority to play a role in the way the whole process is managed, even after the award of a contract, and possibly that could be something here. All right, so let's now move to Paulo, who will be discussing his thoughts about the report, what Eduardo mentioned, but also the situation in Brazil.
I think it's a fantastic, very rich material with a new understanding of the subject, in particular with this perspective of BRICS. Well, Eduardo presented we have this economic theory of two-sided markets and multi-sided platforms. So how do we apply it in competition policy? What we can take from this theory and the difficulties in enforcing competition law based in this type of new theory. And I think they did a very interesting job. What I try to do here is to move to a different perspective, more a comment in the whole idea of the book. So more in lines with the public policy and not exactly the how to apply the economic theory to a particular case. And I think it's a lot has been said on that matter. So it's difficult to be both original and reasonable. It's it's easy to be original and unreasonable. But I will try really to say something that may be new and maybe not consensual, but reasonable. Well, of course, let's begin with something that is a cliche. We've been experiencing an extraordinary change in how firms compete and how firms interact with consumers. And there are already some consequences, so I just will highlight some of the ones that has been remarked frequently. So higher markups in the economy, inequality increasing, and not so much in the way that is captured by the Gini index, but more related to the income that the very, very rich retain. Also data private issues and the big techs, but I will use now a different name, the tech giants. It's not just big. It's the problem, I think it's the being giant. And I will try to respond to taking this consequence. First, what of these consequences are really a problem that we have to tackle, that we have to put our efforts to overcome? Second, given the problems, what's the role of the competition policy? What competition policy can do to tackle these problems? And third, is there some leeway for BRICS coordination to tackle these problems? So that's the whole idea. So it's more a comment on first chapter, also the fourth chapter of this book. So let's begin with the markup. So I submit that high markups are not necessarily bad. They may be high because the cost went down and price is more or less the same. And this actually is something that we do have some evidence in these markets that the markups are higher because of that. So marginal costs are very low in the digital economy. So we expect markups to be higher because of that. Also, we do have some evidence of quality and aggressive pricing in this area. So nobody is complaining that Google search is not working well. So the problem is maybe it's working so well that it's very difficult to have a competitor equally efficient. So I would put aside for the moment the high markups as a problem, but we still have the other three consequences. The second one is inequality. I would side with the ones that see this as intrinsically a problem. So inequality is something that we have to deal with. Maybe it's not specific to digital markets. So we do have problems of inequality in my country, Brazil. Actually, inequality decreased after 2003. So the last 2 years increased again, but due to the recession. But it's something that we had for a long time, like more than 100 years. And what we do have is already tested alternative policies to deal with inequalities. In the case of Brazil, conditional cash transfer is a policy that was tested, enhanced, and now is doing a pretty good job addressing inequality. So maybe it's better to stay with policies that are specialized to deal with inequality. And also, it seems to me that competition policy does not exactly address the inequality of income among persons, because we are dealing with firms. I mean, the profit of a firm is distributed to the owners. And we don't have in competition policy any means to distinguish if the company is held by several people, so it's distributed the profit, or not, if it is concentrated. This is simply not, at least for now, part of the competition policy analysis. And we do have in competition policy concern and with the inequality among firms. But this is not exactly the inequality we were referring to in the distribution of the income across citizens. So it seems to me that we do have better policies to address the issue of inequality, although inequality is definitely a problem. So let's move ahead. So let's talk about the tech giants. Then the question is size intrinsically a problem? Is small always beautiful? I don't think that's the case exactly for the features of the digital markets. We are talking about markets with economies of scale, economies of scope, network externalities. So small is costly. But still you may have a problem. So my claim here is that small is not always beautiful, maybe too costly, but we still have at least two problems. So the problem is that, at least to my first thoughts on this theme, appears. One is they are so efficient and so entrenched in their fields, mainly as a conglomerate, that they have the capability, a fantastic capability, to deter entry and to prevent competition. I'm not claiming they are doing that all the time, but they have the ability to do that. And this is the comparative advantage of competition policy. Competition policy was designed to prevent this type of abuse. So this is a problem that definitely we have to deal with, and I think what Eduardo presented is applied exactly in this area. But I think there is also a second problem. Maybe they are too big, they are giant, to be properly regulated. So when we think about the way of enforce competition policy, we think as there is a competition authority that has authority, that has the means of implementing the regulation. Maybe these companies, they are so huge that they may affect the regulatory process, the electoral process, and also, taking the case of Raisa, maybe the judicial process as well. So even judicial review may be affected, and then the enforcement and the efficacy of competition policy may be mitigated by the ability to affect all these areas of the government. I'm convinced that this is something to worry about. I'm not claiming that we have the solution for that, but something that we have to think about what to do with this. Also take into account that small is costly. So is there a need for a change? So a lot of people talk about some proposals like focus on competition, not consumers, no price effects, no market strategies, less focus on the definition of the relevant market. I heard this type of argument several times. And I think they're right, but they are not new, and they are not specific to the digital economy. I think we are talking about this a long time. And so important questions, but I don't think this is particular for the digital economy. In particular, the definition of relevant market, we've been talking about this 25 years ago with differentiated markets and all these things. They make sense, but not that specific. So what would be specific? One of the ideas is the breakups. Should we break up these economies, these tech giants? Well, if we have economies of scale, economies of scope, network externalities, what's going to happen? We have a much more costly economic structure, and then after breaking up, one of them probably will succeed and will gain the market again, and you have to make them. So we have to deal with that. There are economies of scale, economies of scope. We are not going to change that. So it's a curse, like a curse. We must have some very big companies. But there are two things that maybe we are not dealing with sufficient restrictions to these companies. One is acquisition in adjacent markets. I think this is becoming more consensual now, that they are always change what is the product, what is the boundaries of the market, and what is a no-market and concentration becomes a concentration in few years. I mean, sometimes even less than that. So I think this is something to really care. And also, there is leeway for intervening both in competition policy and regulation in facilitating entry. So we may have one company that is there winning almost all the market, but we may have some rules that make the entry always contesting. So the contestability of the market being all the time providing the competitive pressure that we need even with high concentration in those markets. Is competition policy enough? I don't think so. I don't think that we should put everything inside competition policy. And the reason there are some things that are more adequate for, more appropriate for ex-ante regulation, such as rules for data sharing, data portability, open standards, everything that is good for facilitating entry. But this for ex-ante regulation it may work better. And one thing that is not so easy to put, not so conventional, but maybe we need an asymmetric regulation. We may need a regulation that is more restrictive for companies that are very, very big. I mean, companies that are entrenched in the market. So we may really have something that is more lenient towards entrants, how the entrants should behave, but more restrictive to these very big companies. Do we need a new digital agency? I think there is also, of course, every country has its own institutional design, but there is definitely room for a discussion of regulation in a particular agency with a particular expertise on that. Is there a role for BRICS coordination? So this is my last point. Well, institutionally, I think the BRICS countries are very different, very different. We do share some features, but I think the regulatory problems are similar. So first, we may learn with shared experience. So this is something like an event, not only today, but mainly the next days that we have. This is pursuing this venue. But more important, I just proposed that ex-ante regulation may be an interesting approach, setting standards. If we are talking about setting standards that facilitate entry, for instance, then there is a fantastic opportunity for coordination among BRICS countries, because the feature that we share is that we have fantastic domestic markets. 5 countries with a fantastic portion of the population of the world and the income of the world. And when we say about standards, we benefit from network externalities. That's a feature of standards. So if we have coordinated standards for facilitating entry, this is something that maybe makes a difference. So that's all for the moment. Thank you.
Thank you very much, Paulo. Very interesting remarks. Just a few comments before I pass the floor to Alina and then open up for discussion. With regards to the diffusion of shareholding, I would say that this is, one might agree or disagree with that, in the sense that first, not everyone is a shareholder. There are countries, I don't know how is it in Brazil, where actually a minority of people is basically a shareholder. Mostly upper class, middle class, but no working class. And then, they don't really have the pension funds that we see in other jurisdictions, which to a certain extent might participate. So from that perspective, there might be an issue there with regards to equality. The second issue is, you mentioned also, and very much agree, about the role of smaller countries in this world of giants. And by smaller countries, I don't necessarily mean small in size, but it could also be that many of even the BRICS countries could be considered as small if they had, for instance, to divest a company like Google or Amazon. So from my perspective, this is a problem that we already face in the context of merger control. I find it very unlikely that a jurisdiction like one of the BRICS jurisdictions could block a mega merger. And what actually I've been suggesting, and I did a speech on that last year at the NYU conference, but is that we are thinking about merger control as a regulatory game. So you have a regulator and you come to the regulator to ask for approval of the merger, but I think it's better to apply a bargaining theory game. And this is something that we see very much in investment treaties. There's a lot of literature about that, but no one has applied that in the context of merger control. Basically, the idea is that you're not there to block the merger, but you're basically there to get something out for your own jurisdiction in terms of remedy that could favor some of the interests in your jurisdiction, and then let the other thing pass. And I think maybe we have the same problem here. So that's about some of the comments, but I think Alina has quite interesting comments, in particular also with regards to shareholding and diffusion. Alina?
The previous panelists covered some vital aspects of the competition in digital eras that are discussed in much more detail in the report. What I wanted to do in the next few minutes is to highlight another fundamental aspect in which I believe it's useful to think about the questions of and the problems of competition in the digital age, and that is data. In particular from the perspective of asymmetry in data aggregation that we currently see in the digital markets, and the regulation around the data privacy for the consumer. Specifically in the digital markets, we can see data as a separate resource, almost as a separate market, and at the moment we do not have that many models that analyze how this market is shared by the tech giants, by the new coming digital companies. We do not have that many models that look at the way consumers treat their private data as a resource. Now, in industrial organization, whenever we analyze competition, normally would make an assumption that consumers are making rational decisions about their resources. Can we make the same assumption when we talk about the data? Well, when was the last time you read the full terms and conditions when you were updating your app? The research shows that On average, a consumer values their private data at about $10, and the range can be between 0 and 100. And for a digital company, that's a signal that the consumer is making informed decisions, they're signing away their data, they're allowing to aggregate it. Now, from the competition point of view, what does the aggregation of the data mean for the long-run consequences? What does it mean for the possibility of the new market entry? As Paulo highlighted earlier, we observe higher markups on the macroeconomic scale, and that has particular effect on the inequality, especially in the BRIC countries. Well, one of the reasons is the downward pressure on the costs. The other reason is the more aggressive pricing. One of the things that makes more aggressive pricing possible is the better knowledge of the company about the consumer. If the Amazon has the data about the consumer's preferences, about the consumer's purchasing activities, maybe they have some idea about their habits, that allows them to extract a much larger profit margin and also aggregate this information over time. This raises another issue, which is to do with the merger. If this part of the data set is then merged during the merger with another data set that comes, for example, from another part of the same consumer identity. So, for example, their banking, their insurance preferences, which gives us better understanding of their risk preferences, that enables an even larger consumer surplus extraction. And again, if we think about a tech giant holding this information and then a new entrant attempting to compete on the existing market, can we talk about historical case of having this competitive advantage and exclusionary practice? Because effectively, as Eduardo mentioned, if we look at the long run, companies may take short-term steps to gain long-term profits, which could be the case of, for example, giving consumers apps for use for free, and then in the longer run, extracting more consumer surplus through being better able to adjust their pricing strategies. We have examples where this kind of things are regulated. So, for example, predatory lending is one of the examples where we don't assume anymore that the consumer makes a rational choice if the long-term consequences are difficult for them to anticipate. Should we allow people to make such long-term choices about their data privacy? That's one of the questions I wanted to highlight. For the competition specifically, I'd encourage ourselves to think about what does it mean for the long-term opportunities for the market entry, given that aggregating consumer data appears to give significant comparative advantage on many levels.
Thanks very much, Alina. Very, very good points. And in particular, I think we all probably have read, or we should read in case you haven't read, the book by Zuzana Zuboff, Surveillance Capitalism. We are talking about not just transaction platforms, but predictive platforms. I mean, they're there to predict what we do. And of course, we have been discussing in the report the emergence of personalized markets. And I think you raised a very important point about the consumers not knowing the value of their data or not knowing how much valuable their data is. And I think that is because of a missing market. I mean, there's no a market for data because there are no property rights on data. And at the same time, because of the multi-sided structure of these markets, the consumers do not have information about the value of their data because these are exchanges between the advertisers and the platform to which they don't participate. So therefore, they are not really able to understand what is the value of their data. So I think that is really bringing the point that was made by Paulo before, that we need basically to think not just what we can do through competition, and of course competition may play a role, but also how we can develop a toolkit approach. This is what we put forward in the report that will also combine a number of other institutional reforms, including possibly the creation of missing markets in data. Now that's the 11:30, but that's not the end of this session, because we want to spend at least 15 minutes, if possible, or 20 even. I'm looking to Alexey because he's the maestro here of this symphony.
Sorry for preoccupying too much of your time, but I have a question to Paulo, because I think it was a little bit kind of provocative statement you made, to be honest. And this provocation I found in a statement which sounds very, I would say, rational and kind of obvious even, but at the same time, I think it does require further elaboration or scrutiny. The question is, you're saying Google is great, doing great job. And all these digital companies, they inevitably become big, huge giants. So it's this kind of a way things are operating in the digital economy. There is no alternative option. My question is to you is what is counterfactual and what is basically basis for this statement? And I'm asking because, we used to reality we live in, and we accept this reality as probably default one, but whether there were possibilities which would be different, and I do see a lot of failed attempts to build different kind of realities, and those failed attempts actually, they could succeed. And they could succeed because of certain, different architecture of global economy, of legal frameworks, of different reasons, but there is no inevitable outcome of this. And let me just give a couple of examples, and one of the examples related to the country we right now here, which was kind of Soviet project of innovation-driven economy, which did fail, but whether the failure of this project was due to natural logic of technological development, or was it because certain, external pressure, political imbalances, small or bigger flaws and mistakes made by the leadership, they led to this type of outcome. And the question I'm asking to you about counterfactual is, back in 70s, when most of the countries invested huge amount of resources into technological breakthroughs, it was big science era, when all countries spent huge portion of their budgets into the fundamental science, which as an outcome produced this type of digital, and not only digital, but also biotech companies and startups and then giants. So these spendings of the government resources, they had a certain plan underlining the strategy. And this plan was envisioning a society where we would have a number of technological services, number of technological products available for people. We would be treated very well in terms of medicine. We will be have all sorts of transportation facilities available to everyone. We would have new materials. We would have completely new environment, which would be extremely human-friendly and so on. But as an outcome of all those major spendings, we got iPhones, we got entertainment, we got, pervasive advertising. We got many nice things, probably, which we do value to a certain extent. Nice search at free search at Google. But whether it's compatible to the resources society spent during the second part of the 20th century, whether it's compatible to the amount of, award these guys are getting. Yeah, I'm just asking the question whether you're saying small is always costly. I'm not sure, actually, because this argument we hear in agricultural sector and big companies in agricultural sector, they're much less efficient than small farmers. It's pretty much proven. If you compare the efficiency on the level of enterprise or micro level, I'm asking the question whether these guys are providing services and these services are intrinsically good because they're giants, or because there is no alternative and we just can't compare. And they giants maybe not because they produce good services, but maybe because they just have unlimited source of financial resources coming from investors, and this is architecture. This is design. So this was done by design. So if we just change the design, and the last point I would say, look, when we have about alternatives, regulatory alternatives, we're talking about all other means to tackle inequality and putting competition law in a more technocratic and sole, purpose-focused modality. But at the same time, we see that, let's say, California right now introduced new legislation saying Uber drivers are workers, they are labor, they have to have rights. Yeah, it's very exceptional. Very few countries doing this, very few jurisdictions doing this. In the heart of Silicon Valley, they want drivers to be secured, socially secured, because there are a lot of reasons for this. Comfort, security, and so on. Yeah, I'm done. So, but whether if we would have this type of regulation before, Uber wouldn't happen. Probably it wouldn't happen at this scale. Yeah. We would have different IT solutions for urban areas. Yes, but I'm just saying if we are not capable to produce regulations which would be ex ante at the same time taming these giants, why wouldn't we empower competition law more? Why wouldn't use its flexibility and its tools, which are slightly different from the tools of ex-ante regulatory approach in different sectors, to be more aggressive. And maybe that could also help cooperation fallacy, because we have collective action problem on the state level, which you mentioned pretty much. In regulation, impossible to coordinate. It's impossible we will all come with the same legislation towards Uber. But with competition law, there is hope. Is a question and
the questions and very insightful remarks. Let's probably gather a few more questions and remarks, and then we have time. Yes. Okay.
So I'm Avirup Bose. I'm a professor of competition law at General Global Law School. So I have two quick questions, one to Raisa and the other to Paulo. Now, I was very interested in, I wanted to ask you a little bit more about your conclusions of your research, because being a developing country, you obviously want to have more automated or at least evolve towards such public procurement mechanisms because of the rampant corruption in many of our sort of procurement processes, coming from a country where 40% of the public exchequer money routinely is lost towards corruption. So, how do you balance? Because as a state, you can't choose the number of competitors that exists in a particular market. And yet you should have aspire towards better solutions for having those processes. So how do you balance that? And to Paulo, I had this very interesting aspect of inequality among firms which you talked about. And I want to just probe a little bit you among that. There's this growing sort of debate about the role of state in how firms compete, specifically in 5G. You have China's example as far as Huawei is concerned. You have India's example as far as some of the e-commerce and telecom players is concerned, an increasing role of the state to kind of evolve them as, erstwhile understanding of national champions. So and this has come, I will explore this more on my panel, as a question of competition concern, whether firms apparently placed on the marketplace have same ability to compete with each other. So, just a little bit more, if you could say about the political discussion as far as Brazil is concerned on that aspect. Thank you.
Thank you, Professor Casolari.
So it's a broad questions to the panel, and so I'm Giacomo Calzarai. I'm an economist at the European University Institute. So I'm perfectly at ease with the ideas of two-sided markets, scale economies, efficiency, network effects, and all these is tipping markets. Digital markets actually they already tipped. So if we look backward to the bold decisions in antitrust last century, at the beginning of last century, when some very large companies were broken apart in the US, if we look at the reason that led to those decisions, was probably more than efficiency, was political influence, too large political influence of these companies. And I haven't heard about this topic from the panel. I was just asking you whether there is a shared view about this. And my little contribution on this is that we really lack transparency of what these companies are doing, how they are using data, and information that is generated by markets and market users.
Björn Lundqvist, I'm professor at Stockholm University Law School, and I participated in this BRICS report that we've been written for this past year.
He was adopted like me from the BRICS community.
Yes.
Yeah.
But my question was a little bit so I'm from Sweden. We actually had a number of economists winning the Nobel Prize in economics, and they often put questions to them about competition and so on, efficiency and so on. And often you get the answer, yes, competition is very good, but it's very costly. It costs a lot. It's a try and error process, an innovation process that is not really very efficient. If you really boil down to it, if we would come up with a better system, that is more efficient, then perhaps we should select that. And if we talk a little bit about these new platforms, it seems that the cost of predicting how firms and individuals would buy stuff is that is the cost which is lessened now with the new system, with the digital or the platform economy. So that would imply, of course, that in the end, we will have platforms selecting the products for us, so the services for us, not only individuals, but also then other firms. Do we want that? Is that a good system when we are not consumers anymore? We are the object of something that someone else is selecting for us. We are, homo consumensus is leaving us, and we get a new. Maybe it's a good thing. We become interested in art, and we can go to university for our entire lives and so on. So the question is a little bit, also an issue is about how do we invent this try and error in this platform economy? Because when small firms or entrepreneurs to put forward a product to the market and say, does this work or not? Okay, not, then we change it a little bit, and then we put something. What is going to happen to the entrepreneur in the platform economy? And I put this question to all of you because I think this is. It's a quite interesting issue, and we should facilitate entry. You said, Paulo, but an ex ante regulation. But if that is always very costly, then how will that win? How would the new product ever be able to do that? Or is it so maybe that the platforms in themselves can facilitate a try and error process, an innovation process? That's my question.
Thank you. Quite a lot of questions. So let's start maybe with Paulo, who got most of them, and then what's left, the rest will take.
So first, Alexey, if we have network externalities, huge economies of scale and economies of scope, then it's a consequence of that features that one company will emerge as dominant. So this is just deductive reasoning. Not always in digital markets we have that. Sometimes we may have small companies that are quite efficient and will survive being small. But generally speaking, this is a feature, I think it's more or less consensual that this is a feature of these markets. This does not mean that that the tech giants that we see now will be the tech giants that we have in the future. If we do nothing in terms of competition policy and regulation, probably they will stay there. But if we reduce cost of entry, so answer to Bjorn, so the problem is not entry is costly. The problem is creating a regulation that reduces the cost of entry. That, for instance, we have common standards that are available to everyone. So this decreases the cost of entry, and then a company with something slightly different, a new idea, very small, may enter and may gain the market. Also, public policy is important for challenging those giants. So let's take the case of Uber in China, in 2 BRICS countries, in China and in Russia. So now they are minor stockholders or shareholders. So they gave up competing here. And they gave up competing in China as well. And part of this was, at least I don't know about Russia, but in China, there was this was a public policy to have a very strong local company competing. And this, I think, it's a very interesting role for intervention, I think, in terms of national development. And so I think we do not disagree in this point. My point is I don't change my point that given the features of digital markets, a large company will emerge. And now I just downloaded here what's the name? Yandex. I downloaded Yandex because I cannot use Uber and I don't see many competitors. I think it's the best one. So I am one of the customers now. Other comments. Inequality among firms. This, I think it's very interesting. We have several policies, not only competition policies, procurement policies. Typically, they have different, some specific policies to leaven the field. Acknowledging that some companies have an advantage for being big, and there is a benefit of the competitive pressure that small companies may have. If you have a symmetric regulation, you may have more competitive pressure, and this may be something that legitimates this asymmetric regulation. It's not that easy in terms of political economy. When you have a symmetric regulation, you have problems related to the political economy. What brings me to the next point, which is the political aspects of this discussion, your point, and also entrepreneurship. I think these are the main points that I made in my talk, at least that was my intention. What is typically outside the traditional competition policy, but is a problem that may be tackled by the competition authority nowadays, is exactly the political problem. It's the problem, what I said is, maybe these companies are too large to be appropriately regulated. Why? Because they may affect the electoral process, the regulatory process, and the judicial process. So all the conception that we have of a working competition authority, we have a judicial review that's independent, we have an electoral process, a legislative process that is independent, but if these companies are too large, they may bias those decisions, and then the regulatory process and even the competition policy will not be applied in the way that we thought it would be. So this is something that I think it's unconventional, but something that we have to think about. And regarding entrepreneurship, the idea of setting standards and lowering the cost of entry, it's exactly to allow for entrepreneurship, to allow new companies that may become giants in the future, but still with lower entry, because then we have new entrepreneurs that will challenge them and have the competitive pressure. The point is not having too many companies. The point is to have competitive pressure, and this may be with new entries all the time.
Thank you. Some brief comments, Eduardo, or I mean, you don't have, in case you have.
I mean, you mentioned in the beginning about defining markets or not. I think, unfortunately, for most competition authorities, you must go through defining markets because you must have an objective way of determining dominance. But it made a lot of sense in traditional, more than bricks and mortar, maybe more material, not services, a structural conduct, performance analysis, which competition policy draws a lot from. But when you go to services or even in differentiated products, you already see some strains on the idea of having to go through determining markets.
Yes, please.
Okay, just two kind of quick comments. Alexey, I just thought I would kind of jump on that same Uber bandwagon and to just kind of corroborate what you're saying, the kind of in the South African context. So what's happened with Uber in our country is the regulatory response has been to straitjacket kind of e-hailers and to try and force them into a kind of metered taxi paradigm. And I mean, the unfortunate consequence of that is to mean kind of excessive red tape and kind of registration requirements and licensing requirements that makes actually kind of entering the e-hailing kind of industry quite difficult, onerous, and maybe undesirable. So that kind of does corroborate.
Not only for Uber.
Yeah.
For any company.
Yeah, but that's what I mean. For kind of emerging companies, it's even harder because of Uber's dominance. And then I think it was just your question on kind of how you balance kind of innovation with proper procurement process. And, you know, I think, yes, I mean, digital platforms hold enormous promise to kind of revolutionize governance, you know, and we want to leverage that. But you also have to kind of balance that with accountability. And, you know, I think my point is that when government issues a tender, rather than saying we want X and only X, when the reality is that maybe one at best two, you know, providers could potentially offer that, it's potentially better for them to say, look, we would like X, but we're willing to consider X, Y, and Z. And you know, in doing so, they're more likely to award a contract that they've kind of holistically considered. They've considered the kind of service offering holistically against price and many of the other kind of variables, rather than saying, look, we only want X. Inevitably, then X provides that service, and you have to appoint X, and there's very little accountability that flows from that. Whereas if they're forced to kind of, you know, price competitively, even though they provide the most desirable solution, you're more likely to have, you know, a more responsible service provider. Cool.
I give a brief comment on Bjorn's point about the dichotomy between costly competition and efficiencies that comes from the platforms, because I think one important aspect that we should consider is, well, who's saving on the costs, because that feeds into our discussion about the raising social inequality, especially in the BRIC countries, because we could argue that there is cost savings on the consumer side from, you know, lower cost of search, but I think a lot of the intuition would be that the cost savings and the larger profits would result on the platform side.
Excellent. I just have some very few comments also with regards to Paulo's discussion about the inevitability of dominance. I agree in this context, although I have to say that BRICS countries have an advantage. They have a huge market size, and at the same time, for instance, I'm thinking about fintech. Very few people basically have bank accounts, so there's a huge potential there to develop. Compared to, for instance, the EU, where most people have their bank account, so you have to convince them to switch to a fintech bank. So that offers opportunities, and maybe, I mean, just thinking one opportunity might be even more there. Secondly, you can actually deal with this problem of learning effects, network effects, etc., by mandating access to data. So you put everyone at the same level, or creating data commons. Or, through technology solutions or data pools, also technology solutions like blockchain, which basically enable everyone to keep their own data themselves. So nothing is basically, there's no intermediary in this context. who harvest the data. So from that perspective, you take out the advantage they have, and anyone actually is able to basically develop that. You also see various intensities of network effects. That explains why the dating market is oligopolistic while the search is monopolistic. So you can actually see a lot of different types of market structures. And with regards to Alexey's point about TINA, there's no alternative in digital antitrust. I will agree. And actually, an example that he could have put forward, because I know he talked about it and actually he acted in this context, is the Russian investigation against Google in Yandex, basically. I mean, in the time where basically, if you look to the results of this competition enforcement, in Europe we waited for 8 or 9 years for the Commission to take the Google decision, but that was really too late. I mean, there was nothing left. In Russia, they basically did it in 6 months, and they managed to save Yandex, and therefore have now it's a duopoly, but it's better than a monopoly, right? So I think that shows how important it is to be very quick in acting, maybe to develop interim measures more. In this context, and not to enter into this TINA kind of ideal that, at the end of the story, one will win. Well, maybe not. Maybe we haven't arrived to this tipping point. It's always very unclear what is the tipping point. I mean, you don't know. It's only after the fact that you know what is a tipping point, right? So, and I think that might be a good indication for acting, basically, even if maybe the tipping point has already happened. Okay, so we move now to a break.